good morning, and this is the way the board meeting should look. Just full of people, interesting people, and I'm so happy to see everyone here. We have an interesting subject today, and we'll get started. Norma, would you call the roll?
Yes. Director Davidson?
Here.
Director Radiman?
Here.
President Underhill?
Yes.
Director Mills?
Here.
And Director String?
Here.
Item number 2, because we do have a lot of public, I bet we'll have public comment this morning. And if anyone would like to address the board, please step up to the podium. No, okay. All right, that was one of the things that I do want to bring out is the fact that, you know, we are being televised for a reason, to show our constituents, to show our transparency. And one of the things that inevitably happens is that people aren't speaking into the microphone. You know, you come up to the podium, please adjust it to fit your sound. And I'm asking that of the board also, and the staff. Please speak clearly and loudly enough. Okay. Item number 3 is the consent agenda. Item 3A, approving authorized signers on the following bank and investments accounts. Umpqua bank account, and that would be resolution 2015-39. Wells Fargo custodial account, resolution 2015-40. And local agency investment fund, resolution 41.
I move for acceptance of the consent agenda.
I second that.
Director Davidson?
Yes.
Director Radiman?
Yes.
Director Mills?
Yes.
Director String?
Yes.
And President Underhill?
Yes. And here we are with our presentation. This morning, we are having an overview of California water rights law and CCWD water rights. And water rights, we know, is front page on every newspaper for the last week or so, or for the last month. We know how important water rights are, and I'm just very pleased that this has been brought forward by our general manager, Dave Egerton. We have probably the room full of expertise as far as water rights is concerned, and this morning we'll be all thinking on the same page, hopefully. Yes. Dave?
You bet, Madam President. I really appreciate that. I wanted to thank everybody in the audience for coming today. It's some familiar faces. I very much appreciate you being here. I hope that you'll find this educational. I think you will. I know a lot of you already have that background in California water rights and deal with it directly on a daily basis. But we're really fortunate we have Kevin O'Brien is going to lead our discussion today. Kevin is a partner with the firm of Downey Brand in Sacramento, and he is one of the foremost experts on California water law, and having been in the number of battles over the years to be able to tell us kind of where we're headed in the state. And there's a lot of things that are changing right now, a lot of developments, both on the legislative and the regulatory side, and things that are happening at the State Water Board. And Kevin will share that today. As well, I'd like to welcome David Cameron. He's also a colleague of Kevin's at Downey Brand, and both David and Kevin are our water law counsel, and we're very fortunate to have them as well. I'd also like to recognize John Mills. John is a consultant that works for us on water policy issues, primarily at the state. He spends many of his days down before the State Water Board, the Delta Stewardship Council, and other venues representing our interest, and has a wealth of knowledge, and he'll be joining in as well. So with that, I'll turn it over to you, Kevin, and you can lead us through the discussion. Thank you. And also, I know we're going to have questions that you're going to want to ask, and Kevin, maybe if you want to, I know probably every slide, maybe every bullet point could elicit a question, but maybe there'll be points where you want to stop and take questions so that you don't have to be broken up your train of thought as you move through this.
Yeah, I think that's a good idea. Thanks, Dave.
Can I just make a request also that that if the board asks you a question that probably doesn't need to be asked in public, then you would, give us a heads up on that. I mean, particularly, if we have any specific things that maybe are out there, would somebody please speak up and make sure that we don't cross that line?
Yeah,
Okay,
thank you. Well, good morning. It's good to be back with you. I used to teach a course in water law at UC Davis a long time ago, and it was a 10-week course, 2 nights a week. So you're going to get the hour-and-a-half version of that 10-week, 2-night-a-week course this morning. I hope I don't cover too much ground, but I think we can hit the issues that are of most importance to Calaveras County Water District. I would, as Dave said, I'd like to keep this pretty informal, so if, as I go through this, there's questions or comments, happy to have a little bit of exchange. I think this is really interesting material. I think water law, frankly, is a really interesting area of law. It's very, very tied, as you know, to the history of California, going back to the mining days. And obviously, very much in the news right now. I said to somebody recently, it's never a good sign when you're getting more calls from reporters than you are from clients, all wanting you to explain water rights law and comment on what's going on with the state. But that's the world we live in this year with the very, very severe drought we're in. So I expect that'll probably continue for a while. So, Dave, if you could pull up my PowerPoint, I think it's...
Dave, I'd like to make a comment too, that I think there's some folks in the audience that are also going to have some interesting questions, but at the same time, in the interest of brevity and keeping everything kind of moving forward, that somehow if we can kind of combine, a few questions possibly from the audience as it relates to maybe some of their districts or stuff, we may learn a little from that as well. So.
Okay, so this is what we're going to cover this morning. First, going to cover surface water rights. I'm going to spend a little time on groundwater rights. I know that's not a huge issue for CCWD, but I think it's important to have a general understanding. You've all heard about the Sustainable Groundwater Management Act that's just coming into effect, and I'm going to talk about that a little bit. And then I'm going to spend some time talking about some of the events that are occurring this year and frankly right now in terms of water right curtailments. So surface water, we're going to talk about types of rights to surface water, water right priorities, concept of reasonable use, and the public trust doctrine. The first category of surface water rights is riparian rights. And California is a little unusual amongst the western states in the United States because we actually have what we call a dual system of water rights. We have both riparian rights and appropriative rights. Typically, riparian rights have been limited to more wet climates, particularly the eastern United States. The legal doctrine came from England. And the basic concept of a riparian right is that if you own land that at some point in the history of that title to that land touched on a water course, either a stream, a creek, a river, a lake, some natural water course, that you essentially automatically have a water right to use water from that water course unless something happened in your chain of title to what we call sever the right from the land. And so with riparian rights, you don't have to go to the state of California and get a permit. You don't have to get any authorization. It simply exists by virtue of your ownership of the land as part of the bundle of rights you get when you own the land. And I'm going to talk a little bit about how you confirm whether you do or don't have a riparian right here in a minute. The riparian right is only for direct diversion. It does not include rights to store for more than 30 days. That's obviously important in California since given our climate, typically it's wet in the winter and dry in the summer. So for that reason, riparian rights in some areas are not as useful as the appropriative rights. Your right is limited to use on the riparian parcel, and I'm going to talk about what that means exactly. And the final thing I'll say is that riparian right holders have equal priority amongst each other. In other words, one riparian doesn't have a higher priority by virtue of the fact that their land was bought earlier than another. They basically share the available water supply in a drought on essentially a pro rata basis. In an agricultural context, that would probably be based on irrigated acres, and a court would allocate the water amongst all the riparians based on basically proportions that they own in terms of acreage. So how do you determine if you have a riparian right? I have historically had a lot of experiences in my career where people say, well, I have a riparian right. And my first question is always, well, how do you know you have a riparian right? And typically the answer is, well, my land is right next to the river. And unfortunately, it's not quite that simple. You have to, in order to confirm in a definitive way the existence of a riparian right, you have to review the entire chain of title for the parcel of land. You have to get a title expert to go out and prepare a chain. You go back and you start with the patent, which was essentially the deed from the U.S. or the state government that started the private ownership of the land. And you have to look at each deed or instrument in the chain of title to determine whether there was anything that extinguished the riparian right or severed it. Sometimes you come up with big surprises when you do that. I recently did a riparian opinion for some vineyard land, and the owner had assumed that there was a riparian right there. The land was right on a creek, had been irrigated for many, many years from the creek. Well, it turned out when you went back and looked at the chain of title back in the 30s, the then owner of the land, which was at the time a fruit orchard, had carved out a bunch of lots for his children, about 10 lots right in the middle of this what's now a vineyard, and hadn't preserved the riparian rights on those lots. And so this particular owner had a big hole in the riparian right. And so I guess the point is, a lot of folks assume they have riparian rights. I think increasingly people are having to go through the process of actually confirming that through a title review. And frankly, that's probably important to know what you have. So we're seeing a lot more people that have historically felt they had riparian rights go through the process of getting that confirmed. That's kind of a growth area of our water law practice, frankly, is riparian owners wanting to have a confirmation of their rights.
Can I ask a question about that?
Yeah.
In regards to, most of the rivers in Calvert, well, all the rivers in Calvert County are impeded. And for instance, at Hogan Reservoir, above the river, it goes dry every year. And so is there a timing issue? I mean, after New Hogan Reservoir was built, there's water in the lower Calaveras longer. Is there a riparian right subject to pre-Hogan, or is there a date that's associated with it? Because the water wouldn't be there
Right.
if the reservoir wasn't built.
Yeah.
And so, I mean, does that change the downstream riparian right? Do they only have rights to the original flows on the Calaveras? And when I say the original flows, I assume that, 60, 70 years ago, it used to dry up.
Yeah.
And so they would only have those riparian rights for a certain period of time. Is that the case, or how does that work?
Yes, that is an important aspect of the riparian right. A riparian right gives you a right to the, quote, natural flow that would exist in the stream. And as we know, on many of the streams in California, there are reservoirs. And so in order to determine whether there's riparian water available, you have to do basically an analysis, a hydrologic analysis, assuming no reservoir there and no stored water in the stream. And that's the increment of water that a riparian would have a right to. So in streams where there's snowpack up high, assuming there's snow, which we didn't have much of this year, but typically there would be natural flow through the summer in those watersheds. And other watersheds that are really rain-fed watersheds where there's not much snowpack, typically the natural flow would run out at some point in the summer. And the only water that's in the stream would be water that's been stored in the wet period and then released. So probably in this area, that would be the case. You would have some streams where there would be no riparian water after a certain time.
Can a landowner use a well to collect the subterranean river as a riparian?
If the well taps into essentially the underflow of the stream, then the answer is yes. That would be all part of a riparian diversion, although through a well. And that's not an uncommon situation. For example, in the Russian River watershed, there are a lot of wells that essentially tap into the Russian River, but you have to be able to show you have a riparian right and that you're using the water on your riparian land. And the state board is getting more strict about forcing you to show that.
Okay, thank you.
Yep. So one of the other important aspects of riparian rights is that they are not subject to forfeiture, which means loss due to non-use. Appropriative rights, which we'll talk about in a minute, are subject to the old use it or lose it rule. 5 years of non-use can subject an appropriative right to forfeiture. Riparian rights are a little different. Typically, you don't use them when you don't lose them when you don't use them. Although there is one situation in a stream adjudication where they essentially can lose their priority. And then finally, the rule we've talked about a little bit here, riparian lands can only decrease and never increase. So the important point there is that once a riparian right is lost on a piece of land where a deed doesn't properly preserve the riparian right, you can never get it back. So that's why it's important to review these chains of title and make sure you understand what has happened in the chain of title. Let me talk for a minute about the concept of priority, because that's a really important concept in water right law. All water rights have some priority, and what that means is that the priority date essentially determines your rights in a situation of shortage. In a wet year where there's plenty of water around, priority dates aren't important because essentially there's enough water for everybody and you don't have to worry about priorities. In a drought like we're in now, priorities become very important because they determine who has to cut off their diversion and use of water based on the fact that there's not enough water. And if you've been reading the newspapers, you know that this is actually happening now. We've got State Water Board has issued these curtailment orders. It's essentially said there's no water available after a certain priority date. It's now kind of moving down the chain into the pre-1914 rights. There's been some discussions about doing some curtailments of riparian rights. I don't know whether they will get to riparian rights or not. So this is all sort of playing out in front of us this year. The thing about riparian rights is that typically they have the best priority date on the system. Typically, there's one exception I'll talk about. But if you have a riparian right and you confirm that it's a valid riparian right, typically you would have to cut off last after everyone else on the chain of rights on that particular stream. The one exception is there are certain very senior appropriative rights that were established usually in the 1800s, where the appropriative right was actually established before the riparian land came out of state or federal ownership. The patent was issued. And in that limited situation, the appropriative right can actually be ahead in priority of the riparian right. But that's fairly unusual. So typically, riparian rights, very, very good priority, very senior priority.
This is a question that we may not want to answer, but I'm going to ask it. Is there any responsibility by our board or any other water district in the county to oversee these riparian rights as far as when they are being utilized, to make sure that they are being natural flow or during the natural flow? I mean, do we have that responsibility as a water agency?
I don't think you do. I think that's really a State Water Resources Control Board function. Now, you have the ability, if you believe that someone is illegally diverting water, you have the option and, you know, arguably even the duty to report that to the State Water Board, to have them investigate it. And frankly, the Water Board is getting much more aggressive about enforcement of water rights, as you probably have read. So if something comes to the attention of the district and your sense is that maybe there's an illegal diversion going on, I think the proper path there would be to bring that to the attention of the State Water Resource Control Board and let them investigate it, because they're really set up to do that.
Kevin, I have a question. Consumptive versus non-consumptive water rights. I assume that that's both riparian and appropriative?
Yes.
Okay.
Yes, riparian rights can be used in some cases for hydroelectric, for example, and frankly, a lot of small hydro projects have been operated based on riparian rights in California. And we'll talk about non-consumptive as to appropriative as well.
And so just quickly, because it's a relatively small thing, but my understanding is that in your deed, you could give up your riparian water rights, and that's mostly consumptive water rights. You can still go back and possibly get non-consumptive water rights on that same property.
Yeah, it's an interesting question. That it depends on the language of the deed, and frankly, a lot of the old deeds weren't that specific. You know, you can make the argument that they were just focused on consumptive uses because that's usually what they were most interested in. Consumptive use, by the way, just so everybody's on the same page in terms of the terminology, consumptive use is basically where you're taking water out of the stream and it's not coming back to the stream. That's in simplistic terms. So non-consumptive use of hydroelectric is sort of the classic example. You're taking water out of the stream, you're running a turbine, and you're turning the water back into the stream. There's no net loss of water, at least not substantial net loss. So you have to, you know, and I've read a lot of these old deeds, and a lot of times people, when they sold a parcel of land, let's say somebody owned 1,000 acres that fronted on a river, and they wanted to break off a chunk, a couple hundred acres, and sell it, but they didn't want competition from others in terms of the stream flow. They would essentially sever and extinguish the riparian right as part of the process of subdividing that land. But they weren't always real specific about things like non-consumptive uses. So you have to sort of figure out what was in the minds of the folks back then and do your best to decipher the language of the deed. It can be a little difficult.
Have you ever had a situation where you've said, well, that the water right being extinguished was actually non-consumptive, and someone go then after a consumptive water right?
No,
All
I've
right.
never seen that. Because people were generally focused on consumptive water rights, yeah. Okay, let's turn to the next category of surface water rights. And I'll just say at the outset that these rights, from a sort of numeric standpoint, are a lot more important than riparian rights. I'd say, I mean, I've heard the number, 85% of the water that's diverted in California is diverted under appropriative rights versus riparian rights. So in general, these are the rights that are used for things like the Central Valley Project, the State Water Project, a lot of Calaveras County Water District's rights. In fact, all of them are appropriative, some pre-1914, some post-1914. So this is probably by far the most important type of surface water right. And one of the important things about appropriative rights is they can be both for direct diversion and for storage. When I use the term seasonal storage, that basically means storage from one season to another, which is typically defined as storage for more than 30 days. So obviously, again, looking at our climate here in California, where we have wet winters and springs and dry summers, the storage element is very important, and that's why appropriative rights are really the predominant right in California. The way an appropriative water right is perfected is by applying the water to beneficial use. We'll talk about the concept of a water right permit a little bit. A water right permit is essentially the first piece of paper that's issued by the state of California when you get an appropriative right. And as the way it's been described to me by engineers that work in this area, is a water right permit is like a hunting license. It essentially gives you the right to go out and divert water and use water, but until you actually do that, you have not actually established the water right. The use is the step that's really critical in establishing and what we call perfecting the appropriative water right. And appropriative rights, unlike riparian rights, can be used on any land that's described in the water right permit or license. So typically you'll get a permit, it'll say in the place of use portion, it'll refer to a map that was part of your application for your permit, and that map will define where you can use the water. And sometimes you go in and you ask to expand that area. Sometimes it started off small and you want to expand it, and that's a fairly simple process to go through with the State Water Board. So there's two different types of appropriative rights. And you've probably heard, I know there's been a lot of newspaper articles in the last few weeks about so-called pre-1914 water rights, which can be a little confusing to folks. Basically, what happened in California was in December of 1914, the state legislature passed and the governor signed a law called the Water Commission Act. And that was the law that essentially said, from here forward, we are going to administer our water right system through a state-administered system. And in order to get an appropriative water right in California from that point forward, you're going to have to come and apply to the state, and the state's going to ultimately issue you a permit or ultimately a license. So that December 19th, 1914 date is basically the point at which the state stepped in and started administering and granting water rights. Prior to December 19th, 1914, it was a little different system. In fact, going back to the days of the miners in the 1840s and 50s, you could essentially establish a water right in California by simply going out and building diversion works and digging a ditch and putting the water to beneficial use. And there's a famous old case, Irwin versus Phillips, that was essentially the case that established the concept of first in time, first in right, where the California Supreme Court said, you know, this is how you establish an appropriative water right in California, and that eventually was confirmed by acts of the legislature. And so up to December 19, 1914, it was kind of a loose system, and you could essentially divert water, use it, and it was optional, but you could file what was called a notice of appropriation, which is a notice you filed with the county that says, I am confirming that I have established this particular right by these acts. So obviously, pre-1914 rights are very valuable in the sense that they have a very senior priority, back to the priority concept. And so in a drought year like this, having a pre-1914 right typically has been a good protection against any curtailments. This year, really for the first time, although there were notices of curtailment of pre-1914 rights in the 76-77 drought, this is the first time the state has actually said, we're not only going to declare there not to be water available, we're going to go out and actually take enforcement action against pre-1914 rights. And I'll talk about this a little bit later, but there was just a major enforcement action started by the state board against the Byron Bethany Irrigation District down in Tracy, which holds pre-1914 rights, and the state board has said we're basically seeking $1.5 million against you for illegal diversions. That's going to be a very interesting proceeding to watch.
Excuse me, Kevin, the original law was entitled what?
The Water Commission Act.
The Water Commission.
Water Commission Act, right. So when you talk about pre-1914 versus post-1914, the main difference is post-1914 you get a piece of paper from the state that says this is your water right, this is the quantity, this is the place of use, this is the point of diversion. Pre-1914 it's a little more nebulous. And one of the problems with pre-1914 water rights is sometimes it's hard to prove what was happening prior to 1914. So if someone claims they have a pre-1914 water right and has claimed that for years and years, but the documentation may not be there, and obviously there aren't many folks around, if any, anymore that were around back then that could actually testify as to what was going on in 1914. So some water districts have taken this very seriously and have very good records and have done a very meticulous job. Some have even gone to the extent of hiring PhDs in history to compile historical records, going back and looking at local newspapers and trying to determine what sort of agriculture was occurring, just to confirm the historical record that these rights were being exercised prior to 1914. But in other situations, frankly, the proof is pretty lean. And I think one thing we're going to see is the state board insisting on proof of what's the evidence for this pre-1914 right. And if the evidence isn't sufficient, I think the board is going to basically try to extinguish some of these rights. And obviously people are going to fight over that because they're very, very valuable rights.
Thankfully, we have Larry. So.
Yeah.
Are you going to talk about the authority of curtailment? I mean, are you going to talk about that later? Under what authority they're going to?
Yeah.
Okay.
I think that's a really interesting point, though, just to remember that a lot of these pre-1914 rights that are still used today to provide a public water supply originated from mining, and
Yes.
kind of tracking the use of that over time. It might have gone from mining to probably to agriculture and then to municipal supplies, but there's a whole lot of history involved with that, and in our area you still see the remnants of that because a lot of the systems are the actual flumes and canals that were used for mining purposes are still operating.
Yeah.
Yeah.
And that's why I say people didn't go after them now saying, well, those are really non-consumptive. They were mining, they were run through whatever and emptied back in, and even though the quality was obviously different.
Yeah, that's an interesting question, is if it started out as a non-consumptive right, essentially, could you really convert it to a consumptive right after 1914? I'm not going to give you an opinion on that here, but I think that's a little bit shaky. The other thing that's important about pre-1914 rights is this concept of forfeiture I mentioned earlier. With an appropriative right, if there's a period of 5 years where that right wasn't used, it's subject to forfeiture. The forfeiture doesn't happen automatically, but it's subject to the State Water Board or someone else arguing that there's been a loss of the right. And as Dave was mentioning, a lot of these rights are old mining rights. Sometimes the mining uses continued on through, but a lot of times, as you all know, with the ups and downs of metals prices, some of these mines would shut down for 5, 10, 20 years, and I think there's always a little bit of a question as to whether the right was maintained all those years. I've actually done some work for some mining companies where some of them have actually, where they've been in a shutdown mode. For example, a silver mine shuts down because silver prices are inadequate. They've actually literally started up their mining processing at least once every 5 years to make sure that they maintain their water rights, even though that's an expensive proposition. But they understood that if we lose these rights, we're going to be in trouble.
So it's consecutive.
It's consecutive. Yeah. And it's complicated by the fact that in a drought year, you don't get dinged. So if you don't use water in a year where there's no water, basically, that's okay. So figuring out whether there's been a forfeiture or not is not always an easy thing, but it is a question that you have to ask yourself when you're talking about a pre-14 right.
Do you envision a time when downstream folks are going to start to contest those rights?
I do. I think you're starting to see there's a major complaint that was just filed recently against some diverters in the South and Central Delta. It's a little different situation because the gist of that complaint is that the water that would have been available under pre-14 rights or riparian rights in the Delta was not of sufficient quality without stored water being in the mix to allow those rights to be exercised. But I think as water supplies in California continue to tighten, which we're seeing, and you know, if we continue in a dry mode, hopefully this drought ends, but I think we're still going to have a lot of dry years ahead of us. I think you're going to see more and more aggressive action to scrutinize some of these old rights that frankly have never been scrutinized carefully.
Kevin, maybe just to point out, if there is a challenge of forfeiture that's raised before the State Water Board, the water right holder would have the burden to prove up that water right. So you know, that can be a complicated and expensive process, like you said, because it may really be a historian that you have to retain to do that kind of work.
Right. Yeah. No, it can be very, especially if you're talking about a pre-1914 right. It's probably the toughest to prove up because there's no piece of paper typically. I mean, sometimes there's one of these notices of appropriation, but a lot of times there's not, and you have to construct a historical record to try to prove it. One of the largest water rights on the Sacramento River, Glenn-Colusa Irrigation District, is largely pre-1914 water. I know that district has spent a lot of effort compiling records of diversions, and you know, they've got very solid database on what was going on because they knew that this might someday be important. Others, not so much.
Kevin, I got a question then. Is there a database kept on what I would consider adjudicated water rights where they've been through the process and have proven their standing?
Database is probably not the word I would use. Let me put it this way. There is a database that the State Water Board maintains for post-1914 water rights, which they've been working on it for about 10 years, and it's actually a pretty good database now. And they have started to require more information to be filed about pre-1914 and riparian rights. The adjudicated streams are a little different because they're essentially administered under a court decree. A lot of times the State Department of Water Resources acts as the water master for those streams. And so I just had to look at one recently up north where they actually had a website for this particular adjudication, and it was pretty good. I mean, they had pretty good records of diversions and the rights that were part of the decree. I think other streams that have been adjudicated are not quite that far along, so it's a little hard to generalize.
Thank you.
And just maybe so everybody understands, an adjudication, and we'll talk about this in the groundwater context, an adjudication is essentially a court process where all of the claimants to a water right on a particular stream or in the groundwater context in a particular groundwater basin are brought into court, and the court essentially has a trial to determine who has what rights, and at the end of the process you end up with a judgment that essentially lists all the rights by priority, because that's important, and typically by quantity, rates of diversion, or volume of water that you have a right to. So some streams in California have been adjudicated, most have not. Some basins have been adjudicated, most have not.
One quick question you'll probably get into is we hear of this area of origin reserved water rights.
Yes. We could spend a whole session on that. I'll give you the short version. So when they were thinking about building the Central Valley Project and the State Water Project, CVP goes back to the 30s, I think, and the State Water Project a little bit later. The areas where these big dams were going to be built were concerned that essentially all of their water supply was going to be siphoned off and sent south, essentially. And so as part of the legal and political process that predated those projects, there were some laws that were passed that were, the intent was to deal with that concern. And essentially what what they call area of origin statutes, and there's several different types within the California Water Code, essentially what they say is that the rights of the projects, the CVP and the State Water Project, are to water that's surplus to the needs of the areas of origin. In other words, the areas where the water originates. So to the extent that there's surplus water, you can take it and use it beneficially, but to the extent that we need it here in the area of origin, we retain our rights to that water. Unfortunately, it's a little more complicated than that, and typically in order to protect those area of origin rights, you actually have to go through the water right process to acquire the rights and to then put them to use within the area of origin. And so there have been a lot of court battles over the last 25 years about what those statutes really mean. And frankly, I think the jury's still out a little bit on some of that. And it's not quite as clear as I would like it to be. I represent a lot of districts in areas of origin, and you know, I frankly wish those statutes were a little more clear that on this issue of surplus versus area of origin. And I think there probably will be more litigation on that issue. Okay. So just to round out the discussion, we talked quite a bit about pre-1914 rights. Post-1914 rights, it's pretty simple process. Not necessarily simple to actually get a post-1914 right, but the process itself is fairly simple. You file an application to appropriate. The Water Board looks at the application, determines whether it's adequate, and then issues a notice of appropriation. That typically gives the entire world 60 days typically to file a protest to the application. And the protest can be based on one of two things. It can either be based on injury to water rights. In other words, if you're another water right holder on that stream and you think that by granting this permit you may be injured, or it can be based on the argument that granting this water right would be contrary to the public interest. So that's a little broader, obviously. It takes into account things like impacts on fisheries, impacts on the environment, that sort of thing. Thanks, Dave. Application, notice, protest, and then there would typically be a CCWD document that the applicant would prepare. If it's a major application, probably an environmental impact report. And then at the end of that process, if the protests can't be resolved through negotiation, the Water Board would hold a water right hearing, and at the end of that water right hearing process, the Water Board would make a decision on whether to grant the application. And if so, what conditions might be placed on the application. So from beginning to end, depending on how major the application is, it's typically I'd say a 2 to 5 year process at this point. Sometimes more if it's a complicated situation with a lot of environmental issues. But I'd say 2 to 5 years is pretty typical.
And Kevin, the cost of that, I mean, that could, particularly if you have to do an EIR, can often be over $1 million or more to successfully pursue that. Yeah,
it's not an inexpensive process. You know, again, depending on how many protestants. We did a major application on the Santa Ana River recently. I say recently, in the last 15 years, where there was a number of environmental issues in terms of impacts on fish and endangered species and that sort of thing. We were ultimately successful. We did obtain a water right permit. The total cost of the process was about $20 million. But I would say that the client, now looking at the cost versus what they obtained in terms of the permit and the value of water in Southern California, I think they would tell you that that was a bargain. Because, you know, frankly, water is very valuable, especially in places where there's not a lot of it. Yeah. Okay. So a few more things on, I think we talked about a lot of this. We talked about the concept of priority. We've talked about permit terms a little bit. And permit terms can often include things like fish flow releases. If I get a permit to store water in a reservoir, typically the State Water Board would include a permit term that says I have to release a certain amount of water for fish downstream of the reservoir. And a lot of times the battle in these types of proceedings is how much fish flow is appropriate, and everybody gets their own experts to come in and say, well, I think it's X, and they think it's Y, and a lot of times the water board kind of splits the difference. So that's where a lot of the argument occurs. We talked about forfeiture. I don't know if this is kind of hard for you all to see, so I don't know if it's really worth spending time on this. It's kind of a little schematic that I use to, I guess the one thing I would just, I use this for to illustrate how on a particular stream riparians and appropriators would deal with a situation where there wasn't enough water for all of their needs. And in this hypothetical, we've got the rushing river here. We've got a couple riparians that are farmers, and then we have a couple farmers that are appropriators. And I guess I just would underscore the fact that in a typical situation, if there's not enough water to meet all the needs of all the water users, the appropriators would get cut off first in order of priority. So the most junior water right of the appropriators would get cut off first and completely. There would be no sharing of water with that person. You'd then go down to the next appropriative right. That right would get cut off completely. And if there's still not enough water, you would eventually get to the riparians, and they would share water between them, typically based on some kind of an acreage-based allocation. So, and it can get obviously fairly complicated in terms of priority dates, especially with pre-1914 rights. You know, what was the priority date? For a post-1914 right, it's pretty simple. It's the date you filed your application. That's your priority date. And if you get a permit, it relates back to that date. For a pre-1914 right, you basically have to prove, again, when did you start actually diverting and using water, which can be pretty tricky.
Kevin, I get a question. If you could go back to the last slide, the very first bullet there, a senior right must be fully satisfied before a junior right may be exercised.
Yes.
Can you explain that a little bit?
I guess it gets to this issue that appropriative rights are different from riparian rights in that there's not a sharing concept. Okay. Essentially, if I'm senior to you, and let's say I have a right to divert 100 cubic feet per second out of the river, I get that entire quantity or rate met before you get anything.
Yeah.
And if when I exercise my right to 100 CFS, there's nothing left in the stream, you're out of luck.
Yeah.
So the appropriative rights doctrine is a very sort of harsh doctrine in a sense, because there's no sharing of water in a shortage as between appropriators. It's all based on priority.
Thanks.
Reasonable use is an important concept to understand in water law. There was a amendment to the state constitution adopted back in 1928 that essentially said that all water rights are subject to this requirement of reasonable use. This was in response to a famous California Supreme Court case called the Herminghouse case, where riparians down in the San Joaquin Valley were claiming that they, because they were riparians, had the right to maintain the levels of the San Joaquin River at a point where their lands could be flooded naturally just by the overflow of the river, so they didn't have to worry about diversion pumps and that sort of thing. And the appropriators on the river basically said, no, you can't force us not to divert just to keep water in the stream at a certain level. Went up to the California Supreme Court. California Supreme Court said, no, the riparians are right. They have the superior right on the river. they can force you not to divert so the stream flow stays up at a certain level. In response to that, the electorate basically adopted this constitutional amendment that says no, all water uses in California are subject to the concept of reasonableness. And it's, in that case, it's not reasonable to say to some diverters, you can't exercise your right just so others can have certain elevations within a river. That's not an efficient use of water. That's not maximizing the use of our water resources. And so the concept of Article 10, Section 2 is that with respect to all water rights, you don't have a right to waste the water, and you have to accommodate other uses to the extent that that's reasonable. And of course, the issue is always what does reasonable mean? Well, reasonable is a concept that changes over time. And we've listed some examples here. An unreasonable use in 1935 was using water to drown gophers. In a particular situation, that was considered to be unreasonable. In 1967, a famous case called Joslin versus Marin Municipal Water District, a mining company claimed that it had the right to keep others from diverting water off of a stream in order to allow sand and gravel to be deposited at their mining location. And the California Supreme Court said, no, we're not going to allow that. That's an unreasonable use of water to demand that others stay out of the stream just to keep levels at a certain height. And then more recently, in 2015, watering of ornamental turf in the Russian River watershed has been deemed to be an unreasonable use. So this is one of these concepts that evolves over time, and I suspect, frankly, I wouldn't be that surprised if 20 years from now there's a determination in California that watering lawns on a statewide basis is an unreasonable use of water. I think if our water supply situation doesn't improve, it would not surprise me to see the state go in that direction. And I know, I live in the Sacramento area. I see a lot of people taking their lawns out and putting in drought-tolerant landscaping. So I think this is one of those legal doctrines that's going to adapt as changes occur in climate and other things, and probably will continue to do so. And finally, with respect to appropriative rights, is the public trust doctrine. This is essentially a legal doctrine that was first applied in the water rights context in 1983. This is the famous Mono Lake decision, where you had the city of Los Angeles with some very senior appropriative water rights post-1914, was diverting water out of the feeder streams that fed Mono Lake. And as a result of those diversions, Mono Lake was going down and getting saltier, and that was affecting basically the ecosystem at Mono Lake. And Audubon Society and others brought a lawsuit against City of Los Angeles Department of Water and Power, essentially arguing that even though you have these old water right licenses, post-1914 licenses, the state has the ability to go in and change those rights. And this was a pretty revolutionary concept because historically it had been felt that once you get a licensed right, that was kind of a fully vested property right that wasn't subject to modification or change or anything else. But the Supreme Court, California Supreme Court in this case said basically that you have the ability, the state has the ability to come in and change already established water rights if necessary to protect public trust uses. So that was a pretty revolutionary concept, and I think really made a lot of people concerned that a lot of senior water rights around the state were going to then be subject to modification under the public trust doctrine. But that hasn't really happened, and it's interesting, and it still may happen, I suppose, but I think Mono Lake was such a unique factual situation where you had essentially an entire ecosystem that was being affected by these diversions that it's the old bad facts make bad law kind of situation. I think the Supreme Court really felt like it had to do something in that situation, but we really haven't seen the public trust doctrine, at least so far, used to modify a lot of water rights. And part of that is because even under the decision of the California Supreme Court, the court made it clear, and this is really the second bullet, that it only applies, or the public trust doctrine only trumps other water uses when that is a feasible thing. So the concept of feasibleness implies a certain balancing of the interests of the water right holder versus the interests of the public trust. And at the end of the day, either the State Water Board or a court would have to determine in a particular factual situation which use prevails. And so there's always, it's not a situation, and I get frustrated with some of my colleagues in the environmental community who argue that the public trust doctrine means that the public trust always trumps consumptive water uses. Well, that's not what the Supreme Court said in Mono Lake case. And it very clearly said you have to do this feasibility analysis. You've got to balance consumptive versus public trust, and at the end of the day, you make a decision based on the unique facts of the case. So although you hear a lot about the public trust doctrine and how important it is, at least so far, it has not really led to the modification of a lot of senior water rights in California. There are some exceptions.
If it does, I mean, will the takings laws go into effect? I mean, will it be a taking, or could it be? And then would there have to be compensation?
It's a good question, and I think the answer is Los Angeles tried to make that argument based on the Mono Lake decision and was unsuccessful. I think the takings laws are difficult to apply if you're a public agency like the City and County of Los Angeles, Calaveras County Water District. I think it's just a different set of laws that apply, so I think it's a tougher argument to make that you've taken my private property, because it's technically not private property, it's publicly owned property. I think those arguments would be made. So far they haven't been successful.
Seems like we may be hearing about that locally here. Not locally, but the Byron Bethany thing just kind of makes me wonder how that
Absolutely,
shake out.
absolutely, yeah. Okay, so that's it as far as surface water. Anything else on surface water before we move to groundwater?
Kevin, you mentioned licensing of an appropriative right post 1914, and maybe you could just kind of circle. You talked about the permit being the hunting license, and kind of where you finished that process and where a license plays into that.
Yeah, good question. So, as I said, the 3 steps in the water right process for post 1914 rights: application, permit, license. Permit basically says you have the right to go out and divert and use X amount of water, and you have to do that within a specified period of time. And that's called your diligence period. So you're supposed to basically, and usually they give you a fairly substantial amount of time, particularly in the municipal and industrial context, because they realize that cities a lot of times have a long-term growth horizon. But in order to get to the final step, the license, which is the highest and best right you can have, you have to take your permit and you have to put it to use. So you have to divert water, you have to use water under your permit, and that allows you then to go in and ask the board for a license. And typically what they would do is go back and look at your actual water use, and then they would set the amount of that license based on the amount of actual water use. So a license is what you ultimately aspire to. It's the final vested right in the chain, and although a lot of entities have operated under permits for many years, typically you want to ultimately get a license. All right, we're not going to spend as much time on groundwater law because I know it's not quite as significant an issue up here in the foothills, but I think, as you all know, it's an issue that's very much front and center in terms of California water law and water policy, so I thought we should spend a little time on it.
I'm sorry.
Yes.
Can we have questions in, you want them all at the very end, or now we're moving off of surface water? You want surface water questions now?
Kevin?
We can do surface water now, yeah.
All right, just if I can.
Yeah.
First one, back to riparian rights.
Mm-hmm.
When you look through the deed process, is it specific the fact that it was retained or that fact that it was eliminated? I'm just giving you a basis that you may not see them in a property deed.
Yeah. Typically the way it works is, so originally you have a large tract of land that was riparian, that was patented out of the state or federal ownership. Let's say you got a big 1,000-acre ranch that all fronts on a river. Then as you go forward from the late 1800s, someone wants to break off a chunk of that and subdivide it. And let's say this piece that's going to be subdivided no longer touches the river. So the question is, when they subdivided that piece off, did they intend to preserve the riparian right on that piece that no longer fronts the river, or did they not? Unfortunately, what happened a lot of times was the deed was silent on the riparian right issue. And the rule is, if the deed is silent, there's a presumption that the intent was to sever the riparian right.
What about the ones that are right on the creek or the river?
And typically, if the deed is silent, they would typically keep their riparian right.
It would have to specifically exclude them.
Right, right.
Okay. Second one, everything we're speaking about here is California.
Mm-hmm.
Just out of curiosity, if you were in Montana, it's a whole different set of laws.
Montana,
Or any other state.
yeah, I mean, the western states are all appropriation states, basically. So I don't think any of the western states have riparian rights. So typically, the rules I've talked about with appropriative rights would apply in places like Montana.
They would.
Yes. They would not have this pre-1914, post-1914 thing.
I got one last one.
Yeah.
On the public trust or the benefit, I guess. So they're making the assumption and presupposing they're making a decision for a public trust that may have nothing to do with the public. Like supporting fish in a river that the fish don't even belong there because they never were there historically, but they are now due to what we developed. Is that right? So doing those kind of things is viewed as a benefit of the public.
That's correct.
Okay, it's not benefit for the people or the public, it's benefit by somebody's determination of what that is, right?
Right.
So all falls under that.
And it's pretty subjective.
Yeah.
Yes, sir.
Another question about the riparian rights. If there's a stream going down and the two people have riparian rights in the stream, the person who's higher up on the stream is dewatering the stream, so the water comes down below. I assume the person below has a right to have some of that water.
Yes.
And so what is the appropriate procedure for complaining about to try to get to negotiation with that person?
Well, ultimately, you'd want to try to talk to them and work out a deal. If you couldn't do that, the procedure would be you'd file a lawsuit in Superior Court and to get an injunction forcing them to let a certain amount of water go by their property. Yeah. Yes, ma'am.
I have kind of a three-part question on the 1927 state reservation that Calaveras County has,
Mm-hmm.
the streams of McCully watershed. I wondered if you wanted to just talk about that a little bit, but I have two questions about it.
Yeah, this relates back to the area of origin concept. Basically, what happened was, as discussions were occurring about the Central Valley project, the state, as part of some state laws, went in and filed what were called state-filed applications, where they essentially, the state of California filed an application on a particular stream, and there's a number of these around the state, essentially to reserve a certain amount of water for local use so that all the water didn't get taken up through water rights granted to the federal government or others. So there's these state-filed applications that are still on the books in a lot of places. And individual districts within an area of origin, such as Calaveras County, could then petition the State Water Board for an assignment of those state-filed water rights under some procedures that are in the water code. Mr. Egerton knows about this because we worked on this together in his former job, where you basically, in that case, El Dorado County was petitioning the state of California for the assignment of a state file water right. And again, the whole concept is we're gonna reserve some water rights for the areas where the water originates, so that it all doesn't get grabbed up by folks that want to move it to other areas of the state.
So the follow-up questions I have with that is, can water that is in a state reservation be stored or used in a county other than the county for which the reservation was made?
Say it again.
I'll just use real counties.
Yeah.
Could Calaveras County Water District file for assignment of a portion or all of its state 1927 reservation, store the water in Amador County, and use the water in Amador or downstream in San Joaquin County, when it was reserved for Calaveras?
I don't want to waffle on you, but there's a lot of detail.
Nonsense.
There's a lot of detail you'd have to look at in terms of the terms and conditions of the state filing. My gut reaction is the storing of water in Amador probably wouldn't be a problem. You'd have to determine whether there were limitations on the place of use of that original state filing that would come into play. And so you'd have to look very carefully at the old documents to determine whether there were some limitations.
Okay. And then the other question I had was, can all or part of a 1927 state reservation be perfected by temporarily dedicating that water to Delta inflow? My understanding is there's a statute that allows that.
Temporarily dedicating to Delta inflow. Well, you'd have to, I think you'd still have to go through the process of petitioning, and I have not seen that done. It's an issue I have not come across, so that's an interesting concept that I have not heard about, but I wouldn't say it's not possible. Yeah.
There's a question behind you.
Yes, sir. That's a good question. When you refer to Supreme Court, is referring to California Supreme Court? Yes. Okay. Next thing is, when you say water board, those are political appointees. Yes. Okay. Is there any water rights special issues concerning the Pacific Ocean? Because we're going to be getting some water from the ocean pretty soon. Is there any law connecting how much water you can take and how much salt you can take out of it?
It's an interesting question. The question, those who might not have heard it, is are there water right laws that apply to diversion from the ocean? The short answer is no. The laws we've been talking about don't apply to diversion from the ocean. But I've been working on a desal project on the Monterey Peninsula, and there are a whole lot of laws, other environmental laws, that apply to desal projects. For example, Coastal Commission laws in the Monterey Peninsula situation. One of the big issues is whether these subsurface wells that they're planning to use to take water out of the ocean are actually taking water that's out of the groundwater basin there. So there's a lot of issues around that issue. So although the water rights laws don't technically apply, a lot of other regulations do.
It keeps you guys busy.
It does keep us busy.
Thank you.
Yes.
If you have a pre-1914 riparian right, and you choose to use that right for, to send water downstream for protection of fisheries or for groundwater recharge via the stream bed, is that a beneficial use?
Well, let me clarify your question a little bit. You said a pre-1914 riparian right. Those are actually two different types of rights. So,
Pre-1914, I'm sorry.
okay, so you have a pre-1914 right, and you want to basically use that water to keep in the stream, basically. That's an area of law in California that's a little bit fuzzy as to whether you can actually use a water right to just keep it in the stream and claim that that's still a use under your water right. I think under the current state of the law, that's probably not a valid water right use of a pre-1914 right. Now, if it was a riparian right, there is a specific provision that was added to the Water Code, 1707, that says if I've got a valid riparian right, I can actually transfer that water right to an in-stream use for fish and wildlife protection purposes. And I have seen that used in a few situations where there's actually been transferred to a public trust type use.
Good.
All right, ready to move on to groundwater? So this first chart, I always find a little bit interesting. It basically shows the percentage of use represented by groundwater in different regions of the state. The lighter, sort of turquoise bar is the groundwater use in different areas, and then the dark blue bar is the total water use. So you can see in different parts of the state, for example, down on the Central Coast, the percentage of use that comes from groundwater is very high. Not as much so in the Sacramento Valley, fairly high in the Tulare Lake basin area, and et cetera. So as you move around the state, different areas rely to different extents on groundwater, but the important point about groundwater, obviously, is that in years like this, where there's less surface water available for different types of uses, groundwater becomes much more important and becomes a much higher percentage of the overall water use. So that's what we're dealing with this year in California. So when we talk about rights to groundwater, there's basically three types. I'm not going to really talk about Pueblo rights in this context because that's a fairly unique species of rights. But essentially, overlying rights, appropriative rights, and prescriptive rights are the types of rights you can get to groundwater. Overlying rights are just what they suggest. When you own a parcel of land that overlies a groundwater basin, you automatically have a right to use water from that basin. It's very similar to a riparian right in concept. So, if I own 1,000 acres that overlies a groundwater basin, I automatically have, and I don't have to get a permit from the state, I automatically have a right to pump water and use it on my overlying land. An appropriative right in the groundwater context exists. It applies to certain uses, and we're going to see here in a second. The most important types of use for appropriative rights is any use by a public entity is deemed an appropriative right. So if Calaveras County Water District wanted to go out and drill some wells, it would be deemed an appropriative right holder to the groundwater, and it would be second priority to the overlying users. They would have the first priority to that groundwater. And then prescriptive rights, which is a really complicated area of the law, and I don't want to get into all the nuances, but basically a prescriptive right to groundwater is something you can acquire through pumping over a period of time in an overdrafted groundwater basin. So let's take the example. I'll move to my schematic here, which I use. And this is intended to sort of illustrate what might happen in a groundwater adjudication where you've got a bunch of different parties that come into a court and they're fighting over who has what rights to the groundwater. If this particular basin has been overdrafted for a period of 5 years or more, and there's pumping that occurs by the appropriators, in this case, we've got a city D and an appropriator E that might be a district type entity, the appropriators can actually acquire rights called prescriptive rights that are essentially puts them on an equal footing with the overlying overliers. So this is important, for example, in situations where you've got long-standing irrigation uses of water, and then you've got a city that comes along and develops over a course of years, and eventually the basin goes into overdraft, and the city wants to have a water right to pump groundwater that's equal to the rights of the overlying landowners. That would require an adjudication process, and the city would come in and argue, well, we've essentially acquired a right that's just as good as the overlying landowners under this concept of prescription. And basically, they have to show that they've pumped during periods of overdraft, and that's then prescripted or taken some of the rights away from the overliers. Now, there's all kinds of defenses, and there's a concept of self-help, and it gets extremely complicated. So this is just a very small little taste of what prescriptive rights are all about, and it's frankly one of the reasons why groundwater adjudications are so complicated, because of these prescriptive rights issues. But the basic idea of groundwater rights is overliers are going to have the first priority to the available yield of the basin. Appropriators are going to have the secondary priority, very much like riparians and appropriators. And unless you're in one of these prescription situations where there's been pumping during periods of overdraft, those are the rules that would apply typically in a groundwater situation. I hope I haven't completely confused everybody with that, because it can get...
I've got a question, Kevin. Does a 5-year rule apply then to dormant?
Dormant, as the law is now, if you are an overlier that is dormant, that doesn't pump groundwater, your right is respected just like all of the other overlying rights. There is a suggestion in some of the cases that rule may change at some point, and my personal prediction is that at some point the courts are going to find a way to put dormant overliers at the end of the line, because I think there's just not enough water to reserve for people that aren't using their water. So I think eventually we're going to get there, but the law is not there yet.
Kevin, the concept that Texas and California were really far behind any groundwater rights stuff is something that I'd heard a lot of historically. Can you explain maybe the evolution now of groundwater management in California, in particular what's really been going on over the last 5-ish years or so?
Yeah, let me, I'm going to talk about SGMA, the Sustainable Groundwater Management Act. Maybe I'll, if I could, just defer that to that discussion. I've got a couple other things I want to go through, and then I'll come back to that. So from this discussion we just had, obviously the concept of overdraft is a really important issue in groundwater law, because that's what triggers this prescription, which is a situation where water rights can change. And essentially, overdraft is defined as pumping in a basin in excess of safe yield that produces some undesirable results, such as a chronic lowering of groundwater levels, inducement of seawater intrusion, or other water quality degradation, land subsidence, that sort of thing. So if essentially, over a period of time, you're pumping out more water than is being recharged, and you've got groundwater levels slowly declining and other bad things happening, you're in overdraft. Now, that's easy to say, but sometimes it's tough to actually, sometimes there's close calls. And I've been involved in a few of those where, frankly, you could argue it either way. We had a case a few years ago, the Santa Maria Valley groundwater adjudication, where the issue was whether that particular basin was in overdraft. And so we tried that case in front of a judge in Santa Clara County in downtown San Jose. And this judge had no background in groundwater law or groundwater technical issues. Smart judge, but just needed to be educated. And so we spent a lot of time trying to explain what overdraft looks like and what it doesn't look like. And so this is one of the exhibits we used in that trial. This is a hydrograph of a well in the San Fernando Valley. You can't read it very well, but the left axis starts in the 1920s, basically, and it shows groundwater levels basically going down about 200 feet over the course of about 40, 50 years. We basically said, Your Honor, this is what overdraft looks like. In a similar vein, in the Antelope Valley, you've got depletions of groundwater in storage, where over the course of 40, 50 years, you've got the amount of groundwater that's actually in storage decreasing by numbers to the tune of 8 million acre feet. showing that basically pumping is occurring way in excess of recharge in that basin. This is the Salinas Valley, where you've got seawater intrusion that's occurring because of pumping near the coastline. To the right, bottom right, that's the city of Salinas. So you've got this plume of seawater in the Salinas Valley, which is an indicator of overdraft in that basin. So this is a famous picture showing land subsidence in the San Joaquin Valley in the Mendota area, where it's kind of hard to see, but up at the top there's the number 1925. So that's where the surface of the land was in 1925, and then you can see how far the land has subsided between then and the time this picture was taken, which I think was 77. Quite a significant subsidence of the land surface in that area, and that's continuing to occur today due to overdraft.
The gentleman's 8 feet tall, right?
Yeah. I think there's a little bit of optical illusion going on actually. So these are some of the problems that are occurring in the groundwater context around the state. And back to Terry's question, California is one of the few states that doesn't regulate its groundwater as part of its surface water right system. In most of the western states, and I went to law school and practiced in Colorado for a few years, so I saw it there. They came to the realization that a lot of groundwater is connected to surface water streams. That's just kind of a basic geologic fact that, if you go out in the Sacramento Valley or the San Joaquin Valley, the aquifers are typically, at least the upper aquifers are typically connected in some way to the surface streams. And so they made a decision in most of those states, and Colorado did it back in the late 60s, that we're going to, when we grant a water right, or let me put it this way, if someone wants to drill a well, we're going to make sure they have a water right, and we're going to make sure we've evaluated the effects of that well on surface water. And when they get a water right to pump that well, it's going to be just like any other water right to surface water. It's going to be all part of one system. We're going to administer it all together. California never did that. So we have a system that's unique, where we have rights to surface water, which includes underflow of streams, as we talked about earlier. But then we have rights to what we call percolating groundwater, which are completely separate from our surface water rights system. And the problem with that is that there is physical interconnection between the two. And we know that. In some cases there's a lot, in other cases not as much. So it does create some challenges from a water supply management process. Because if you're going to really tightly regulate water in a surface stream, but you're going to let people go, a mile over and put a well field in and basically pull water out of that surface stream, you're going to have problems. And that's part of what's happened in some areas of California, is this sort of tension between our surface water system and our groundwater system. So just last year, and taking effect actually January 1st of 2015, the state adopted a new act, the Sustainable Groundwater Management Act, known as SGMA. And that act essentially requires that what are called groundwater sustainability plans be developed and implemented for certain groundwater basins around the state. And basically the basins that have been designated as either a medium or high priority basin by the Department of Water Resources. And that those basins have to be managed in a way that will meet the goal of sustainability by certain deadlines that I'll talk about here in a minute. Sustainability is essentially like operating within safe yield. It's essentially operating so you don't have some of these things going on. So that over a long-term basis, although you're going to have fluctuation from year to year, that over a long period of time, that line is going to be essentially flat. And so one of the things that we're dealing with now in California is agencies are starting to implement this act and take steps to become what are called groundwater sustainability agencies and to actually adopt groundwater management plans. So all basins that are designated as medium or high priority that are subject to critical conditions of overdraft have to have a groundwater sustainability plan in place, up and running by January 31st, 2020. And local agencies may become groundwater sustainability agencies, or in the absence of local management, state of California can intervene. So essentially what SGMA says is, if you locals want to manage your groundwater, that's fine. Go do it, and this is what you got to do. But if you don't do it, at least for these medium and high priority basins, we, the state, are going to come in and do it for you.
So Kevin, is 2015 going to be in essence the baseline for where safe yield begins and ends, or is if they picked a spot based upon a specific basin?
No, I think what'll happen is there will be, as these plans get put into effect, there will be an analysis done of what is the safe yield of a particular groundwater basin. And eventually there will, in a lot of cases, there will be a number attached to that. You know, let's say the annual safe yield is 100,000 acre feet. And that's basically represents a long-term recharge to the basin. And let's say that pumping currently in that basin is 200,000 acre feet. Well, you basically got two choices. You can either try to increase the supply of the basin through projects like groundwater banking projects and other things, or you can ratchet down pumping. And I think in a lot of areas, the only option is going to be to ratchet down pumping. And so ultimately, as these plans start to get implemented, starting in 2020 for the overdrafted basins, you're going to be dealing with situations where local agencies, these GSAs, are going to have to confront the need to tell groundwater pumpers, you got to cut your pumping by X percent. And that's going to be it's going to be a big deal. I mean, I've had people that work a lot in the San Joaquin Valley tell me they think a lot of land is going to come out of agricultural production in the San Joaquin Valley.
Well, it's just so astounding how much land is going into agricultural production.
Yeah, absolutely.
Even in Calaveras County now, you know, there's 1,000 more acres probably of almonds and walnuts than there was just a year and a half ago.
Yeah.
I mean, and they're digging irrigation lines right now.
Right.
You know, and I mean, again, that's down in the San Joaquin Basin part. But you know, I mean, we're doing work for walnut guys down in Linden and such, and there's no end in sight. I just wonder if there's a building boom, or building the orchard boom, preparing for that date, and then I mean, how are they going to curtail it? Are they going to go priority again? Or are you going to have to? It's just going to be.
It is going to be very, very difficult, because one of the things the law says, SGMA says, is none of this is intended to alter groundwater rights. So in theory, if you're an overlying landowner, you've got a first priority right to take water and use it on your overlying land. So these folks that are putting in new almond orchards or whatever, you know, their basically argument is, hey, we're just exercising our water rights. And you know, frankly, from a legal standpoint, it's probably smart for them to do that now rather than wait 5 or 10 years from now.
I think the one interesting part will be what the demand for surface water and the investment in surface water, how that'll change. Because clearly the San Joaquin Basin is in overdraft, and there's no, I mean, what used to be a development threat now is an agricultural threat. And what will that do for the investment of infrastructure to distribute surface water?
Yeah.
You know, I think that's one of the, you know, brings some possibilities out there, but it's just going to be chaos.
Yeah, and I think ultimately you can't deny the fact that there's just not enough water supply in some of these areas, and I think substantial amounts of land are going to come out of ag production, ultimately. How you get there, I think, is the big question, and, you know, how much pain it's going to cause. But it is, over the next 20, 30 years, it's going to be a big deal.
Well, especially the crops that are permanent, you know, the trees and stuff that need water all the time.
Yeah.
Row crops very much different. But, you know, I don't know if the market's going to determine that, the government subsidies are going to determine that or what. But there's significant government subsidies for new farmers on new ground for trees.
Okay, excuse me, we'll stop with SGMA and take a short break.
Okay? Thank you.
10 minutes?
Yep.
Thank you.
I got to step out a little after 11 to call another board of directors that's meeting that I just have a quick session with them. So, but I think I can finish my presentation before I have to do that. One thing I wanted to mention with respect to Sigma, Dave reminded me of this, is this again only applies to basins that are designated as high and medium priority. And I think with respect to Calaveras County Water District, there's only a relatively small sliver of the district that actually overlies a basin that falls in that category.
I think it's about 35,000 acres.
Well, that's more than a small sliver.
It's basically the west end of the county. We've got maps on it. But,
West end of the county.
I think that's about right.
Yeah.
Basically goes from Valley Springs over to 12 and then beyond the other towards Highway 4. So it's pretty good,
That's
pretty substantial.
Pretty substantial, yeah. So the district will ultimately have to decide whether you want to become a GSA for that area. My guess is there's probably some regional effort that will be underway. It seems to be happening in most places. It probably would make sense to have your oar in the water on that. We're not here today to discuss that particular issue, but you know, that's just, I want to make sure the audience understood this is not going to be something that the entirety of Calaveras County has to deal with, only that portion.
Well, it's interesting what possible impact we could have, because I bet you we're not pumping even a measurable percentage out of the San Joaquin Basin from Calaveras County.
Right.
You know, we're not the problem here.
Right.
And so it'll be interesting when we come to that, what possibly we could do.
Yeah.
You know, complain about San Joaquin County.
Well, and you have water supplies too, so.
We can be part of the solution.
Kevin, to bring up the point, the Calaveras County Environmental Health Department has done several presentations in preparing for this very issue, so.
Oh, good. All right, so anything else on Sigma we need to talk about right now? All right, so let's, last topic is curtailments. We've touched on some of this already. State Water Resources Control Board has gotten very focused on water right enforcement. And frankly, I generally support that. I think, you know, to me, there's sort of two choices here. We either use the water right priority system we have, and we're serious about it, and we enforce water right priorities in a very serious drought situation like we're in. Or if we're not going to do that, we come up with a new system. And you're starting to hear people say, well, the water right priority system is antiquated, it doesn't work, you know, all these districts have these old senior rights, and why should they have the senior rights on the system? You know, you should basically equitably allocate water under some new system. And they point a lot to Australia, which had a very serious drought and basically did a very major restructuring of their water right system in Australia. And I've talked to some Australian farmers about that, and frankly, that hasn't been a happy experience for a lot of folks in Australia. So my personal view, and this is just an opinion, is there's nothing wrong with the priority system. The priority system, I think, works pretty well, but you do have to enforce it. You do have to say that in a really, really dry year like this, where we had the lowest snowpack in history, that certain water rights are going to get cut off. And so the Water Board has taken a series of actions starting early in the year to say, they started telling people very early there's probably not going to be any water under post-1914 appropriative rights this year at some point, and they in fact did curtail all post-1914 rights as of, I think it was May 1st. And then they have proceeded to go down the priority list, and they have now issued curtailment notices for pre-1914 rights going back to certain years. And we've noted here that on June 12th, they curtailed pre-1914 rights back to 1903. And on the Merced, they curtailed back to 1858. I suspect that as we go through the summer, we're going to see a series of these curtailment orders, and they're monitoring the hydrology very carefully, and they're continuing to issue these curtailment orders. Now, there are some legal issues with respect to the state board's jurisdiction over pre-1914 rights. Frankly, that's an area of law that's not completely clear. Historically, the Water Board hasn't had authority to administer or regulate pre-1914 rights. There are some recent court cases that suggest, at least to me, that there may be more authority there than was previously thought. Those with pre-1914 rights, as you know from reading the newspapers, have basically fired back and have filed a series of lawsuits that are now pending that essentially say the state board doesn't have jurisdiction to regulate us. If I had to guess, and this is just my personal opinion, I think ultimately those lawsuits will not be successful. I think the courts, either the courts or the legislature, I think will find a way to allow the regulation of pre-1914 rights in the current situation. But I think there will be a lot of litigation between now and then. Litigation is ongoing. The Byron Bethany matter that just got filed this week, I think is a big deal because the dollar numbers that they put on that particular curtailment notice, $1.5 million potentially in civil penalties, is a significant amount of money. So we're going to be litigating the issue of the extent of the state board's authority to curtail water rights over the next couple of years, and ultimately I expect the courts of appeal will probably weigh in, and I would not be surprised to see the legislature weigh in at some point. So that's kind of where we are with respect to curtailments. I guess the one final thing I would say on curtailments, and this I think is directly relevant to Calaveras County Water District, is that one of the real nice things to have in a situation like we're in now is a right to store water. Because obviously if you have a right, let's say it's a post-1914 right that allows you to store water, and we do get some rain or some snow, and you are able to fill your reservoirs, or at least put water in your reservoirs. If a curtailment comes later in the year, that curtailment doesn't require you to drain the reservoir. In other words, if you've been able to store before the curtailment notice comes, you've got a water supply. And I haven't talked to Larry about your specific situation here in Calaveras. I suspect you have, your reservoirs are down like everywhere else, but that's a very good position to be in. And a lot of districts around the state aren't in that position. They rely on direct diversion rights, and in some cases they're just cut off, and they have no water to provide. I think your forebears on this board, I think, did a good job of establishing quite an impressive array of water rights and a water supply system. I know it's not perfect. I know we all have dealt with different issues over the years, but I think Calaveras County Water District, in my mind, is one of the fortunate ones that has a pretty substantial array of water assets. And I think one of our jobs is to see that you hold on to those assets, those rights. So that's that's my presentation.
I have a couple questions. In regards to the legislature acting, I mean, that's one of the things that worries me probably the most, and I don't know what we can do with it, but, I mean, if you look at the pre-1914 water rights, would you say most are in Northern California or Southern California? Or is it pretty even, or?
I would say just numerically, probably most in Northern California, just because there's more water in Northern California. Yeah.
Well, you can see why sometimes, I mean, unfortunately, and particularly towards the coast, we have more legislatures there, and I think that they're going to be under pressure to make laws that are going to take water rights from area of origin and that sort of thing. So, I mean, that's just a concern of mine. One question I had, when they sent out curtailment notices, because a supervisor sent me a letter that was issued to Rancho Calaveras Homeowners Association, which is a voluntary homeowners association, but they do own some land on the Calaveras River. But they were issued a curtailment. And I was curious as to why they would, unless they held a water right, or did they just do it to anyone that would be on a body of water? How did they notify people?
They used a list that was based on statements of water use that were filed. Basically, every pre-1914 and riparian has to file a statement of use with the state.
So the Rancho Homeowners Association must have had that filed.
They must have had a statement on file.
Yeah, because they have a series of ponds and such there that are, I don't believe they're fed off the Calaveras, but I have also been getting complaints about people taking water out of these ponds, and so I just don't know if it's really affected or not. But
yeah, they probably are on that list of statement holders.
Yeah.
And I imagine your district has received curtailment notices,
Yes.
right? Yeah.
Cindy
I
has
have
a
a question.
Yes.
Regarding the groundwater in Nicholas, if somebody's asking for appropriated water rights, there's that 60-day posting period. What are the requirements of posting? Say LA wants to come pump water out of Calaveras County groundwater. How do they get notified? Who gets notified?
Well, there's a couple different aspects to your question. The 60-day notice period applies to the surface water application process. So if, for example, someone from out of county wanted to come in and drill some wells in the county, there wouldn't technically be a notice requirement for that because there's no state-issued water right you would need to obtain. Now, if it was a public entity, which it probably would be in most cases, they would probably have to do a CEQA, this California Environmental Quality Act, analysis, which would include certain public notices. But as I said earlier, California is unusual in that you can basically, if you own a parcel of land, you can drill a well without going to the state for a water right permit. You would have to get a county well permit, but typically those have been fairly routine permits that are pretty easy to get. So the noticing issues on the groundwater side are fairly minimal.
So you have to own the land.
You'd have to own it or at least have some kind of, you could do it through an easement if it was a properly drafted easement.
Two questions. The tertiary river system, could somebody from the populated areas come in and start digging wells in our tertiary river system and put the water into one of the rivers and then claim that water downstream?
When you say tertiary river system, tell me what you mean.
Underground rivers here in Calaveras County. One of the concerns I have is could, say, East Bay Mud come in and start digging wells in one of the underground rivers or one of the aquifers, put it into the Colony River, and then claim that water downstream?
Well, you'd have to first determine whether the source of the water was basically an underground stream if it was an underground stream, what we call subterranean stream, they would have to first go to the water board for a water. And that would be a long, drawn-out process. If they were pumping percolating groundwater from a basin, then they wouldn't have to go to the state for any kind of water right, but they would have, if it was someone like East Big Mud, they would have to do a secret document.
Three questions. Recently, after all earth-shaking movement over there, NAP all of a sudden finds stuff in their gushers online. Probably heard one. How are they going to determine the source of that water? Is it coming from Calvert County, from Emerald County? Who has the rights? And all of a sudden, we got a gusher. And those gushers can be changed because maybe tomorrow we have another little shake. And it's going to be gusher someplace else. So how is it going to be determined what's the original source? Who has the right to it?
Well, if it's, from a water rights standpoint, the question is it percolating groundwater or is it a stream that's flowing underground? And if it's percolating groundwater, then you own the land, you've got a right to pump it. If it's subterranean stream, then you have to go to the state. That's the quick answer. Yes.
So you mentioned the statement that has to be filed for riparian or pre-1914 water users, and what is actually on the statement? What are they required to provide?
It's a form that requires you to basically state the amount of water you've used during the year of the statement. You didn't used to have to report the actual amount of use, but they changed that a few years ago. So it now requires a sort of higher level of information than historically was the case.
And that was just required in the last few years?
Yes.
So you started that like 2010?
Yeah, you used to see these statements filed, and there would just be check marks on the months that the water was used, but no quantification, and now you have to actually quantify.
Okay, so they're presuming that every single pre-1914 and riparian user is actually doing this?
Yes, they're taking these forms very seriously, and if you don't fill out the forms, they're going to take the position that you've lost your right. I mean, there are some pretty dramatic sanctions for not following it.
Where would I find the information about that, the requirements?
I would go to the State Water Board's website and the Division of Water Rights. You should be able to find the statements of water diversion and use is what you want to look for.
Okay. It's time for you to move on, and
Okay.
I just really want to say we thank you, certainly appreciate the presentation you made.
My pleasure. Lots of good questions.
Uh-huh.
Yeah.
One last question, as far as water transfers, does any of this,
That's what you-
kind of,
Jump ship.
Kevin's got to be outside.
oh, you've got to leave at what, it's 11 now?
I can do one more. Water transfers.
Yeah, water transfers and how that's kind of shaken out amongst all this state regulations.
Well, it's a big topic. I mean, I guess the short answer is, I think water transfers were really important this year to help some areas of the state get through this drought. A lot of water moved from Northern California to areas south of the Delta, I think 250,000 acre feet or so. I think transfers are an important way for the market to kind of deal with allocation issues. And I think the state clearly supports water transfers. The important thing to keep in mind about water transfers is that's considered a beneficial use for the transferor. So I know that the concern with water transfers is always, if I transfer water, someone's going to say I don't need the water. And I get that. It's a legitimate concern, but the law is, I think, very clear now that if I have a water right and I decide to transfer it for a year or 2 years, I get credit for that beneficial use of the water by that transferee. And in some cases, that's really important because you want to keep your use up so you don't run into this use it or lose it problem.
Thank you.
Those are not permanent transfers. Those are maybe 1 or a couple of years
Right.
duration.
Right.
And again, it provides the flexibility for those that transfer to get some value on the water right, establish use, continued use. and then as well helping deal with these challenges throughout the state. So.
Right. You know, and it's just closing comment. I work with a lot of agricultural districts up in the Sacramento Valley, and you know they're feeling under pressure on some of these water right issues we've talked about, and I think they kind of feel like if they try to help with the situation, the drought situation, that maybe that'll help people leave them alone in terms of trying to change the water right system or something like that. Hopefully that's the case, because I think, to me, a market type system makes a lot more sense.
All right. Thank you, Kevin.
Thank you, Kevin.
Appreciate it.
Appreciate it.
We'll go on to item number 5, which is board reports, information, and future agenda items.
I have nothing to report.
It was interesting. I was at the state legislature last week, 2 weeks ago, with the AB 142. It was my first experience in state legislature stuff, so it was enjoyable. But other than that, a lot of the same old, same old. Thanks.
Just remind everybody, the Highway 4 Corridor Committee will be not meeting in August.
I can move up to the
Oh, it's like doing this too, right? Will not be meeting in August. Will be the first Thursday in September at the fire station in Angels Camp. They'll be hosting.
Northeast?
No, at the fire station in Angels
Oh,
Camp.
yeah, but who's hosting the?
Angels Camp is.
Oh, okay,
Yes.
thank you. Okay, well, I stayed local, White Pines Park, and they're going forward with their community stage up at White Pines Park, so we'll be hearing a lot of that. Information or future agenda items? Anybody want? Okay, Dave isn't here, so. Okay, our next board meetings, Wednesday, August 26th at 9 a.m. is a regular board meeting. Wednesday, September 9th is a regular board meeting. And so, item number, Dave, did you have anything you wanted to share about the board or
Future agenda items.
future agenda items?
Future agenda items. Let's see. I don't. Just to let you know that we are, we do have the one meeting in August, and if needed, we will call a special meeting on the Blue Lake Springs proposed agreement, which we're making progress on.
All right, item number 7, we are going into closed session. We have a conference with legal counsel, anticipated litigation. The board will be considering whether to initiate litigation pursuant to Government Code Section 54956.9 D4, one potential adjudicatory administrative proceeding. Conference with real property negotiators, Government Code 54956.8, property appropriative water rights owned by Calaveras County Water District, district negotiators, John Mills and Kevin O'Brien, under negotiation, price and other terms. And then at this point, I ask for any public comment on closed session.
Peter Rich, gentlemen, I would like to see if it's I asked before, and I haven't seen anything on it. Maybe we would consider putting on the agenda. I want to know real estate, where and how much.
This is only on the closed session, public comment period, Peter.
No, she asked for public comment. I'm giving her a public comment. And I'm addressing the director.
Closed session items.
Okay, well, you also passed off, you didn't give me an opportunity for reporting from a future agenda item. And I would like you to consider to disclose all property, real estate property that this agency holds and give a little bit more details. Thank you.
Peter, at the last meeting, you missed formation of a committee to do that very thing.
Okay, so that's going to be a report on it.
Yes.
Thank you very much, ma'am.
Okay. During
We'll actually do it in here, so we're,